Assalamualaikum warahmatullahi wabarakatuh. Innal hamdalillah nahmaduhu wa nasta'inuhu wa nastaghfiruh wa na'udzu billahi min shururi anfusina wa min sayyiati a'malina may yahdihillahu fala mudhillalah wa may yudhlil fala hadiyalah. Asyhadu an la ilaha illallah wahdahu la syarikalah wa asyhadu anna sayyidina Muhammadan abduhu wa rasuluhu la nabiyya ba'da. The Honorable, the entire second Ecologist Commit, highly educated reviewers, and also the attendees of the journal authorship and webinars. On this occasion, I will present the result of our legal research entitled Legal Measures to Prevent Bankruptcy for Debtors of or Companies Affected by COVID-19 in Indonesia. Okay, let me to share with you to the share screen about our presentation. Okay, this research was written by Rahayu Hartini and Briliawan Gambar Rahmatullah, and then Muhammad Aziz Ma'ruf. Okay, let's move on. Okay, I started. This research framework is composed of an introduction, the necessary literature review, research method, problem formulation, result and discussion, and finally the conclusion. Okay, next. Preliminary, as we know, the COVID-19 pandemic has had a tremendous impact on all walks of life in the world. In the economic field, this pandemic has created tension in the economic climate in Indonesia. Among these impacts include the first one has a bad impact on micro, medium, and even micro business in Indonesia. And the second, termination of employment. And the third, and the last one related to the research we raised is the increasing threat of bankruptcy for companies of debtors whose debts are due. If this happens or many companies go bankrupt, this will cause several impacts, including decrease in gross domestic product, monetary crisis, crisis of confidence, inflation spiral, uncertainty or instability, loss of opportunity for the community to supply goods or services to debtors or companies, the loss of need for the supply of goods or service for consumer from the debtors, reduce employment opportunities. Okay, next. As for limiting the expansion of the discussion in this study, this research is limited by the formulation of the problem as follows. The first one, what is the concept of legal protection for companies or debtors that are threatened with bankruptcy due to the negative impact of the COVID-19 pandemic in Indonesia? And the second, can the COVID-19 pandemic be used as a debtor as a reason for force majeure in contractual relationship? And the last one, what legal measures can be taken by debtors or companies that are threatened with bankruptcy due to the impact of the COVID-19 pandemic based on a fast, fair, open, and effective bankruptcy legal system in Indonesia? Okay, next. In this research, we need several literature reviews. Among them are the principle of Belange, in the context of contractual relation related to the principle of business continuity as legal protection for debtors in bankruptcy law. And the second, about the theory of force majeure, which contains the legal basis contained in Article 100, 2044, and 100, I'm sorry, 1244 and 1245 of the Civil Code. The theory of impossibility and the theory of elimination or negation of errors, absolute and relative impossibility theory, and the condition can be said to be force majeure. Next, in this legal research, we use qualitative research methods as well as using normative legal research methods, namely research that refers to written statutory regulation and requires secondary data sources or secondary data. As for us, we use a conceptual and statutory approach as well as using primary, secondary, and tertiary legal materials. Primary legal materials in the form of statutory regulation, and secondary legal materials in the form of books, journals, articles, and opinions of legal experts. Tertiary legal materials are in the form of a legal dictionary, an Indonesian dictionary, and English dictionary. The next, from the legal research we have done, produce a finding and discussion which I will explain below. We found facts from the Indonesian Central Statistics Agency that from 10 to 26 July 2020, the Indonesian Central Statistics Agency conducts a survey of 9 business actors affected by the Covid-19 pandemic in Indonesia. Head of the Central Bureau of Statistics, Kecup Suharyanto, said that there were 3 elements of business actors surveyed, namely large and medium enterprises, small and medium enterprises, and agriculture. Active 4% of small and medium enterprises and active 2% of large and medium enterprises tend to experience a decline in income. Meanwhile, 59.8% of small and medium enterprises and 49.4% of medium and large enterprises are still operating normally. Based on sectors, there are 3 business fields that are most affected by the COVID-19 pandemic. All 3 are in the accommodation, food, and beverage sector. Another survey sector is the transportation and warehousing sector. The rest, the COVID-19 pandemic also threatens the business climate of other sectors. The occurrence of economic climate shocks later became the cause of the increasing number of business or companies that were threatened with bankruptcy. Furthermore, the Indonesian Association of Curators and Administrators predicts that the number of cases of bankruptcy and postponement of their payment obligation will continue to increase during the pandemic. The chairman of the Indonesian Curator and Administrator Association, Jimmy Simanjuntak, said that the trend of bankruptcy application, especially through the delay of their payment obligation mechanism, has so far increased quite significantly. In fact, due to the COVID-19 pandemic, it could increase up to 50% from normal. Furthermore, Deputy Chairman of the Indonesian Chamber of Commerce, Sinta Wijaya Kamdani, said Especially in the hospitality sector, many have almost filed for bankruptcy, especially in the tourism sectors. All countries in the world have now conducted in-depth studies in addressing regulation in the field of bankruptcy law in their respective countries. Apart from that, governments around the world also provide effective formulation to prevent companies what are threatened with bankruptcy. The following is the tabulation of comparison to regulation issues by several countries to prevent bankruptcy of companies or debtors affected by the COVID-19 pandemic. We also conducted research that we examined from the registration data for bankruptcy and delay in debt pay obligation, sorted from the cash tracing information system, indicates that there has been an increase in billing for bankruptcy and postponement of debt payment obligation, which in 2019 there were 1,533 cases, whereas in 2020 it has increased to 2020 it has increased to 536 cases, and that is counted until the third quarter only. And it is predicted that in the fourth quarter there will be an additional 178 cases. Okay, next. From the things that have been mentioned above, then in our first sub discussion, we conclude that there are several important things that need to be done to deal with this problem. Among them, namely, the first one, optimization of legal protection for debtors. Legal protection for debtors or companies that experience financial difficulties are due and are threatened with bankruptcy must receive special attention in order to achieve the ideal of business continuity and save the Indonesian economy during the COVID-19 pandemic. And the second, government policy on prevention of bankruptcy. The importance of government policies is preventing bankruptcy for debtors or companies due to the COVID-19 pandemic. In this case, the government has made efforts to issue these policies, which are listed in the Financial Service Authority Regulation number 11 and number 14 in 2020. We have also included the contents of the regulation in our revised journal, which we will post in the journal Humanities and Social Science Review or Scopus Q1, as well as comparison as legal policies with several other countries. And the third, application of the principle of business continuity in the judge's decision. Judges should pay attention to the importance of the principle of business continuity by considering the perspective of debtor of or companies. And the last one, as well as the revision of the law on the bankruptcy and postponement of the debt payment obligation in Indonesia. Namely, the importance of including an insolvency test in the law on bankruptcy and postponement of debt payment obligation to measure the level of the debtor business prospect. Next, in the second discussion, namely to answer question, can the pandemic COVID-19 create a debtor as a reason force majeure in contractual relationship? The answer is, in our opinion, the theory that is more relevant to the condition of this pandemic, and by looking at the provision in President Decree number 12 of 2020 and 20 regarding the determination of non-natural disaster for coronavirus disease 2019 or COVID-19 as a national disaster. That the presidential decree does not automatically become a force majeure reason to cancel an agreement or contract, let alone eliminate debtors, debt obligations that are past due. The position of this presidential decree is only a gateway for parties to provide an opportunity to be able to restructure contracts, not in the formal of contract cancellation. In this case, what needs to be done is first of all need to pay attention to the situation and condition as well as the character of the agreement made by the parties. Next, thus, there are several legal remedies that can be taken by debtors or companies that are threatened with bankruptcy. Among them, namely the argument of force majeure, but it must be by looking at the form and content of the parties' agreement first. Then, by seeking the first legal remedy, namely through the legal instrument for postponement of debt payment obligation. In this case, an assessment must be sought through insolvency test on debtor. And finally, in when the provision in Article 8, Paragraph 4, junto Article 2, Paragraph 1 in the bankruptcy law and the postponement of the payment obligation have been fulfilled. It is with a heavy heart to protect the legal interests of creditors. The debtors must be bankrupt through the commercial court. Furthermore, the bankruptcy estate or bankruptcy bank will be managed by a person appointed as a curator. Okay. Finally, the conclusion in this study is that one of the issues that is of concern due to the impact of COVID-19 is the number of companies that are threatened with bankruptcy. Therefore, it is necessary to take legal measures for the parties in the context of bankruptcy in order to deal with the impacts of the COVID-19 pandemic. This research answers this problem by providing the following conclusion. And the first one, good application of the concept of business continuity during COVID-19 pandemic. And the second, President Decree number 12 of 2020 doesn't automatically become a force majeure reason to cancel agreements and eliminate debtors' obligation to their past due achievements. However, certain types and forms of agreements can serve as a reason for the existence of force majeure and the gateway to contract restructuring for debtors or companies. And the last one, the application of the PKPU mechanism as the first legal measure or ultimum primum is through various efforts such as restructuring, renegotiation, and or scheduling of debt repayments by debtors and creditors, as well as making the bankruptcy instrument a last resort or ultimum remedium. That's all we can convey. Thanks for your attention and wassalamualaikum warahmatullahi wabarakatuh.
Terima kasih buat kalian yang sudah menonton video dan channel saya. Jangan lupa like, subscribe, comment, and share. Terima kasih. Bye-bye.